matter of Target Group Limited against Commissioners for His Majesty's Revenue and Customs.
Lord Hamlin will explain the decision of the court.
Value-added tax, or VAT, is paid on all services which are supplied for consideration by a taxable person, and its application is governed by a European Council directive, generally known as the Principal VAT Directive. The Principal VAT Directive exempts certain supplies from VAT, and under Article 135(1)(d), this includes various financial transactions. I shall refer to this as the Financial Services Exemption. This appeal concerns whether loan administration services provided by the appellant, Target, fall within that exemption. Shawbrook Bank Limited, or Shawbrook, is a provider of mortgages and loans. Target administers loans made by Shawbrook, including by operating individual loan accounts and instigating and processing payments due from borrowers. Target's case is that its services fall within the Financial Service Exemption. That case was rejected by the First Tier Tribunal, or FTT, the Upper Tribunal, and the Court of Appeal, and Target now appeals to the Supreme Court. In its judgment, the Supreme Court unanimously dismisses the appeal. I give the judgment with which the other justices agree. The Financial Services Exemption applies to, quote, transactions concerning payments, transfers, debts, but excluding debt collection. Target contends that its services fall within the exemption on two bases. First, by giving instructions which automatically and inevitably resulted in payment from the borrower's bank accounts to Shawbrook's bank accounts via the Banker's Automatic Clearing System, or BACS, the payments or transfers issue, and secondly, by the inputting of entries into the borrower's loan accounts with Shawbrook, the loan accounts issue. The payments transfers issue. In the decision of the Court of Justice of the European Union, or CJEU, in a 1997 case known as SDC, it was held that to be exempt, the services must firstly have the effect of transferring funds, and secondly change the legal and financial situation of the relevant parties. This left open the question of whether the services must in themselves have that effect and make that change, the narrow interpretation, or whether it was sufficient for them to have that causal effect, the wider interpretation. In the Court of Appeal decision of Customs and Excise Commissioners and FDR Limited, it was held in 2000 that the wider interpretation is appropriate. Target contends that the later CJEU case law reaffirmed the correctness of the wider interpretation and that this covers the services which it provided. The judgment considers the relevant CJEU case law since SDC in detail. It concludes that the subsequent case law makes it clear that the narrow interpretation is the correct one. This is consistent with the need to interpret the exemption strictly, the fact that its subject matter is financial transactions, and its rationale of covering cases where it is not possible to identify the tax base. The judgment of the Court of Appeal to the contrary in FDR must therefore be overruled. The narrow interpretation means that these services must in themselves have the effect of transferring funds and changing the legal and financial situation. It is not enough to give instructions to do so, thereby triggering a transfer or payment. It is not enough to perform a service which is essential to the carrying out of the transfer or payment, nor one which automatically and inevitably leads to transfer or payment. It is necessary to be involved in the carrying out or execution of the transfer or payment, its, quote, materialization. This requires functional participation and performance. Causation is insufficient, however inevitable the consequences. Target did not provide such services. The loan accounts issue. Target contends that the making of accounting entries is the standard modern means of effecting movements of value, and that, as a matter of EU law and English law, unilateral accounting entries may be sufficient to effect a transfer or payment. In the present case, Target's role included the authorised debiting and crediting of the borrower's loan accounts with Shawbrook, and it is contended that this involved making changes to the legal and financial situation of the parties, and so falls within the financial services exemption. The FTT found that the accounting entries made were of, quote, expected payments, which were, quote, assumed to be made. It follows from the FTT's findings that an entry in the ledger or on the loan account by Target does not itself transfer ownership of any funds or commute the rights of any party. The loan account was no more than a ledger, recording the effect of payments made by customers to Shawbrook, but not affecting such payments. Since the accounting entries made no changes to the legal and financial situation of the parties, they did not fall within the financial services exemption. In conclusion, Target's case on both issues is rejected, and the appeal is accordingly dismissed.
The court will now adjourn.